Welcome to the Celebrity Estates Wills of the Rich and Famous podcast. In this podcast, we break down high-profile celebrity estate planning cases for advisors and their clients. Most celebrity estate catastrophes are based on the same issues that everyday people face, just with the volume turned up. Our goal is to identify and extract the individual estate planning issues that lie at the heart of each story. We then discuss what advisors should expect and how to avoid common pitfalls. Hosted by wealthmanagement.com senior editor David Lenok.
Hello everyone, and welcome to the latest episode of wealthmanagement.com's Celebrity Estates, Wills of the Rich and Famous. For anyone new to the podcast, in each installment, myself and a guest take on a different celebrity estate and attempt to extract some key lessons that planners can apply to their more traditional clients. The idea being that celebrity estate planning stories, although often ridiculous in their details, generally have at their cores very basic issues that can just as easily apply to non-famous or fabulously wealthy clients. We have a returning guest this week, Vivian Thoreen. Vivian is the executive partner of Holland and Knight's Los Angeles office and chairs the firm's National Private Wealth Services Dispute Resolution Team. She's a litigator and experienced trial attorney whose practice, both in Superior Court and in the California Courts of Appeal, focuses on complex trust, estate, conservatorship, and guardianship matters. She represents individuals, families, charities, and financial institutions in cases including will and trust disputes, contested conservatorships and guardianships, breach of fiduciary duty matters, and elder abuse matters. Ms. Thoreen's experience includes some of the most sensitive and high-profile cases in her field, including that of Mickey Rooney, whose story she shared with us in her previous appearance on the show. Thanks for joining us, Vivian.
Happy to be here. Thank you very much.
So our subject this week is another celebrity on whose behalf Vivian has worked, Richard Pryor. Richard Pryor was an American stand-up comedian, actor, and writer. He reached a broad audience with his trenchant observations and storytelling style, and is widely regarded as one of the greatest and most influential stand-up comedians of all time. He had huge success in basically every medium, picking up an Emmy and 5 Grammys along the way, and he also formed a legendary hilarious screen partnership with fellow comedian Gene Wilder. Pryor was also well known for his personal demons, largely because he was so fearless in addressing them on stage. He struggled with alcoholism and crack addiction, the latter of which was the root cause of an infamous incident when he lit himself on fire and ran down a city street. He also had 7 children with 6 women across 5 marriages, although 5 of those marriages were to only 3 women because he married 2 of them twice. And Pryor sadly passed of a heart attack in 2005. His death caused a bitter feud to erupt between his widow, Jennifer Lee Pryor, who he married twice, with whom he had no children, just to make things even more complicated, and some of his aforementioned children from previous relationships. Richard Pryor suffered from multiple sclerosis when he began to deteriorate back in the 90s, and as a result he hired Jennifer, who had previously divorced him in 1982 because of his addictions, to oversee his caregivers and act as his personal manager. In 2000, however, his son, Richard Jr., filed for conservatorship of Pryor. He alleged that his father had deteriorated to the point that he could no longer make decisions for himself, and then complained that Jennifer had limited access to the comedian. Jennifer fought back that Pryor had picked her and an accountant to make his decisions as agents under power of attorney documents, and also as co-trustees of Richard Pryor's trust. The probate judge overseeing the case ruled in Jennifer's favor. In 2001, Richard and Jennifer married for the second time, and in an unusual move, they applied for a confidential marriage certificate, which is not made a matter of public record. So the Richard Pryor children supposedly didn't know of the marriage. And then after the marriage, Pryor amended his trust, naming Jennifer as a primary beneficiary and the person with the right to control all of his intellectual property, including his name and image rights and all royalties from his comedy albums and performances. When Pryor passed away in 2005, his estate was worth an estimated $40 million. After his death, Pryor's eldest children filed suit against Jennifer. They accused her of elder abuse, fraud, forgery, and taking advantage of Richard's weakened mental and physical state. One major point of contention was California's statute prohibiting gifts and bequests to caregivers. But Jennifer prevailed under exemption to the law, allowing gifts if the caregiver was a spouse. So Vivian, Richard Pryor's is one of the most complexly blended families we've addressed on this show, and some conflict was likely inevitable regardless of plan. So at what point of the story did you come into the picture?
Thanks, David. So I came into the picture after Richard Pryor had passed away, and I represented Elizabeth Pryor, one of his daughters, and we'll call her one of the older kids, because for a while there was a division between the older three versus the younger three. And she is the child who led the charge against Jennifer and made just a litany of claims against her, including the ones that you mentioned, trying to set aside the gifts that Richard supposedly left to her under his new estate plan.
Okay, so it seems as if this case really hinged on the idea of Jennifer as a caregiver. Is that sort of a common point of conflict in your experience that you see in these sorts of cases?
It is common, and as you described earlier, I think the fact that Jennifer was both wife number 4 and number 7, if we're counting the actual literal marriages, on the one hand, versus the children with their differing mothers on the other hand, that really set up a scenario for someone like Jennifer to take advantage of someone like Richard. And I want to be clear from the outset that the multi-page complaint that we filed on behalf of our client Elizabeth, we never got an opportunity to really litigate and get to the, quote, bottom of it. So when I refer to what I refer to as the facts, they weren't actually established, or they weren't findings made by court. They're just the allegations. But the care custodian issue is prevalent in a lot of our cases and really leads to what we now call elder abuse. And that's the concept of a care custodian, or to use a layman's term, a caregiver, essentially a caregiver who gets her ward to marry her. And it goes both ways. You know, we have male caregivers who get their female charges to marry them and vice versa. But using the Richard Pryor example, that was the crux of our argument, which is the gift that Richard made to Jennifer during his lifetime and through his estate plan that she received when he died, because she extracted them when she was a caregiver, those gifts are void. They should be canceled out, and she shouldn't get them. And, you know, when I was rereading the complaint that we filed back in 2007, the law was significantly different than it is today. And so had we applied the laws of today, meaning 2020, it would be a very, very different result.
Interesting. How has the law changed then? Well, what's the main difference?
So the main difference is this. Back in 2007, when we filed this, it's as you described earlier, David. So if you're a caregiver, the law said, okay, if you're a caregiver, there's this presumption that any gifts that you receive or any bequests that you obtain in someone's estate plan, they're presumptively void. They're presumptively invalid because we think, based on this role that you played, there was some sort of untoward behavior, undue influence, fraud, or whatnot. But there was an exception, as you pointed out as well, that if you are married and you happen to be a caregiver, or you start out as a caregiver and you get your ward to marry you, then you're good, you're golden, and there is no exception that applies to you because you are basically the spouse. You get to keep everything. So at the time, the mantra that we were using in our prior case was, once a caregiver, always a caregiver. You cannot take off that hat, even if you get someone to marry you. It just isn't fair, because as a caregiver, you're in this trusted position of someone who's vulnerable and who's dependent upon you. So one could argue that it would be pretty easy to get them to marry you, and the marriage itself insulates the caregiver from any kind of blowback. And that was the law at the time. A marriage completely insulated any and all gifts to a caregiver. Now, in 2020, and when I say 2020, I really mean in this year, it took all this time, and there was a change in the statute that only became effective, at least in California, January 1, 2020. So it took all this time to finally get some sort of carve out for caregivers who get their wards to marry them. And it's chipping away slowly. Trust and estate attorneys wanted more in the way of voiding gifts or determining that there was this presumption of invalidity for caregivers who got their words to marry them. And there is a partial carve-out, but, the conundrum is that there's a conflict between trust and estate lawyers on the one hand and family law lawyers, because it's also very natural and kind of common sense that one spouse would leave the bulk of their estate to the other spouse, right? So at what point do you decide that that is not appropriate, and you got to really dig deep? So if we were litigating against Jennifer Lee right now in 2020, then there's no question at all that all of the gifts that she got during the lifetime and on death after the marriage, there would be a conclusive, irrebuttable presumption that she obtained those gifts through undue influence or fraud, and they would be void. So huge difference.
So correct me if I'm wrong here, and also, obviously not all caregivers are elder abusers, and I don't think that needs to be said, but we might as well just get it out there.
Right.
Is there a proper way to give a gift to a caregiver? Like, is it possible in California, or is there a proper way for it to be done? I assume that people, wanting to give a gift to a caregiver is still fairly common, even in the absence of undue influence. Is there a proper way to do that?
Absolutely, yes. There are mechanisms where you can make such a gift. And, there are a lot of, let's talk about the boomers. There's so many boomers right now, right? The caregiver population is going to increase. The need is going to be there. And, I only see the ugly cases, but there are many cases where people want to live their longtime caregivers' gifts. They're grateful, they're appreciative, all of that stuff. And you're right, they're not all undue influencing fraudsters who get their words to marry them. That's really, really extreme. And so there are mechanisms under our code. I know there are mechanisms under other jurisdictions that permit this. So,
and again, correct me if I'm wrong here, my understanding is that California is ahead of the curve for the most part in offering these protections to the elderly. But if I'm an advisor or an attorney in a state that doesn't have a statute like this, that doesn't have this this presumption protecting my elder clients, what are some of the signs that I can look for that a caregiver is exerting undue influence versus just doing their regular job?
Sure. One would be, and if there are advisors out there, that the advisors are on the verge of or do get terminated. A common, bright, obvious red flag for elderly folks who are being abused is that there is a sudden and abrupt change in longtime advisors, professionals whom the elder has worked with for many, many years. Financial advisors, estate planning attorneys, even doctors, medical professionals, and the like, because those are the people who are going to have the greatest familiarity with the elder and would know that something is amiss, right? So the easiest thing for an elder abuser, whether they're a caregiver or not, to do is to just start with a fresh slate and get new advisors who are potentially more loyal to the caregiver or elder abuser.
And it's such an interesting, like an insidious action on the case of the abuser too, right? Because not only is it just smart on their part to sort of take away the dissenting trusted voices so that they're sort of the only trusted voice, but also in so doing, if I'm an advisor or an attorney who gets fired and I, bring up an issue of elder abuse, it also kind of looks like I have sour grapes and I'm upset because I got fired, So it's sort of like this double, yeah.
Well, that in a lot of, not in a lot, but in at least a handful of jurisdictions, financial advisors and bankers, they are mandatory reporters of elder financial abuse. So they have the cover of using their jurisdiction's elder abuse statutes to make a report. And, it doesn't have to be that they know for a fact that it's going on, but there's something that doesn't look right. But, in the cases where we have a caregiver who is really moving in on the elderly person, oftentimes there are children or neighbors or other family members who likely exist, but they're not as close to their family member as they used to be, or they're estranged or something. There's an opening that the caregiver takes advantage of. In a family that is very close-knit, communicative, and there's a lot of love, a caregiver has much less opportunity to really alienate and isolate and take advantage of an elderly person.
And that's also, I think, where advisors can really come in, right? Because even if it's a very loving family and there's just physical distance in between the closest relatives, the advisor, assuming the person's coming in a couple of times a year, you're seeing the checks, you're seeing the receipts in a way that the kids aren't seeing, when they call on the phone or come for the holidays. So in a very real way, advisors are sort of the first line of defense here.
Absolutely. And the advisor, like the estate planning attorney, for example, is going to see that, oh, well, gee, for the last 20 years, you've wanted to leave your estate X, Y, and Z, and now you're telling me you want to cut out your family and leave everything to your caregiver? I mean, that just sounds bizarre and crazy, especially if the caregiver is a relatively new presence in the elder's life. It's just kind of a common sense knee-jerk reaction. So it just doesn't make sense unless you're the elder and you're being what I'll call duped by a caregiver who's really manipulating and taking advantage of a vulnerability that the elder has. And that is what happened to Richard Pryor. I mean, as you described, he, at the height of his career, I mean, he was just the big man on campus, but in his later life, after he was diagnosed with MS, by the late 90s, I mean, he was wheelchair bound, he couldn't talk, he had trouble swallowing, he couldn't even sign his name. I mean, he was dependent for everything. And so that is really something that we allege Jennifer completely took advantage of. And then you've got the kids who are kind of competing for their father's attention. They have different mothers, they're at different places in their lives and careers, and I would say that, assuming the allegations are true, Jennifer was quite strategic in pitting one kid against the other, or one against the others, and just also really capitalizing on Richard Pryor's fear that many elderly people have, which was, I don't want to be in a nursing home. And so what do you tell a person that you have total control over? Your kids are plotting against you. They want to put you in a nursing home. So, I mean, his situation, his deterioration really created the perfect storm for this kind of setup, and it's just really tragic.
Yeah, and it's very interesting because, again, we have the same sort of insidious or similar sort of insidious thing with getting rid of long-term advisors, is that if a caregiver comes in and they, or any elder abuser comes in late in life and marries, the person, the elder, then now they're the step-parent of a lot of these kids. And, I mean, stepmom or stepdad versus stepkid is like the oldest story in will contests, right? So it covers so much of being like, well, you just hate me because you're my stepdad, or you're just upset because you're not my kid or something like that. It's just like, it makes it look like a much more mundane issue than maybe it is.
True. Especially these days where you have estate plans where the step-parent, as the surviving spouse, gets the benefit of the income or whatever assets during that step-parent's lifetime, and whatever's left over on the step-parent's death goes to the children. But you've got a step-parent who is younger than the children from a former marriage, so there's almost no chance that the kids from the prior marriage are going to inherit, and that really sets up a terrific tension.
Yeah. I also think it's interesting because obviously we're using the term elder abuse here and elder care. But elder is really, it's kind of a sliding scale nowadays in both directions. People are living longer, but also in instances of dementia are increasing and things like that. So I think it's important to point out that, when we think of an elder, people think of someone who's 75, 80 years old. Richard Pryor, when this really started happening, wasn't even 60 yet, right? I mean, he had the MS diagnosis and he had become sort of infirm, but he wasn't, by technical age-wise, necessarily what you would look at and be like, this is an elder.
Right. I do not remember how old he was at the time, but more to your point, yes, the elder abuse statutes are broad. In California, it's anyone 65 or older and who lives in the state, but it's really anyone who's 18 or older. So if you're between 18 and 65, you're considered a dependent adult, because and there are specific definitions associated with that. But if you're over the age of 18 and you have trouble living by yourself on a day-to-day basis and you've got to really rely on help, Richard Pryor would easily have fallen under that statute as well. So, and there are other jurisdictions that have really broad, quote, elder abuse statutes where it's anyone over the age of 18. Some states have anyone over the age of 60, which is really young. So it just kind of runs the gamut. But I would say, generally speaking, if you're an adult and you have physical, mental, or other limitations that prevent you from living as an independent person, there is likely a statute or a provision under an elder abuse statute that you would fall under.
Yeah, and it's just something I point out for, advisors and other professionals to keep an eye on, just because you may not be looking for this sort of abuse in a client who's in his, early 50s or mid 50s, even though it's entirely possible that they could be starting to suffer from some of these, infirmities that would, make them open to this sort of thing. So it's one of those, it seems like semantics almost, but it's important to look past the semantics here.
Right, exactly.
So one of the points here in this case was that an issue of attempted conservatorship came up. Do you mind just giving our audience a quick overview of sort of what a conservator does and sort of what role it can play in this whole dance?
Sure. There are two types of conservators, and in other jurisdictions are called guardians, but it's the same thing. There's a conservator of the person and a conservator of the estate. The conservator of the person assists an adult with day-to-day decisions. Make sure they're going to eat. Where are they going to live? They're going to brush their hair, comb their teeth, get groceries, and make sure just their day-to-day living is appropriate. A conservator of the estate is someone who takes care of all of the financial aspects of an adult's existence, paying bills, including extends to participating in litigation, also estate planning, and the like. And it's not uncommon for an adult to have just one of the other. You can have conservator of the person, you can have conservator of the estate, or you can have both. And you can also have different people in each of those roles working together, or you can just have one person filling both roles.
So we're just about out of time. I'd just like to, as I do with all of my guests, kind of put you on the spot here at the end. But this is obviously a very complex issue. But if there's just like one piece of information or advice that you think that our audience, advisors out there need to keep in mind when it comes to sort of issues of caregivers and potential elder abuse, what would that be?
I think it would be the same message as the one you and I talked about when we were talking about Mickey Rooney, which is to keep in touch with your family members or keep in touch with your clients and really maintain an open line of communication because it's really much more challenging for a caregiver or an elder abuser to come in and take advantage of your loved one if there is a really solid family unit. And the other advice I would give is earlier rather than later. I know we all think we're going to deal with it tomorrow or I'm going to live forever or some iteration of that, but it's better to, quote, get your affairs in order, get your estate planning documents in order while you have all of your cognition, while you have just the ability to weigh the pros and cons and the consequences of the decisions you're going to make versus when you are much more vulnerable. And I would consider talking to your advisors about including language that would protect you as someone who's preparing your estate plan, to protect you from attacks from caregivers or elder abusers such that they can undo whatever documents you're having prepared now.
Yeah, it really is amazing. Some 35 odd episodes into this show, depending on when this actually publishes, and talking about all manner of topics all across the estate planning board. The communication is the single through line through everything, where it's just everyone, more often than not, when I ask that question at the end, people say, the guest will say, it's communication. Because it really is true that, it's so much easier to solve a problem before it starts than it is after it becomes a problem. And communication really is the way to make that happen.
I totally agree. In the cases that I get, and I only get them when they're in the ugly or about to become ugly phase, someone is estranged, someone cut someone else off at some point in time, there was some sort of breakdown. Families that are close-knit or have this line of communication, I don't meet those families. My colleagues who are doing the estate planning or administration, they get to interact with all of those intact families. I only meet the dysfunctional ones. And the running theme in my matters is that there is some breakdown there at some point.
Well, that's all the time we have. I'd like to thank Vivian Thoreen for being just a fantastic guest once again.
Thank you very much, David. It's my pleasure.
And for all our listeners, I'll see you, or I guess you'll hear me, on the next episode of Celebrity Estates.
Thank you for listening to the Celebrity Estates Wills of the Rich and Famous podcast. Click the subscribe button below to become notified when new episodes become available. The information covered and posted represents the views and opinions of the guest and does not necessarily represent the views or opinions of InformaWealthManagement.com. The content has been made available for informational and educational purposes only. The content is not intended to be a substitute for professional investing advice. Always seek the advice of your financial advisor or other qualified financial service provider with any questions you may have regarding your investment planning.